Welcome to the deep dive. Today we're pulling back the curtain on a courtroom saga from 1960s Sydney. It's a legal drama that honestly reads much more like a true crime thriller than, dusty old case law.
It really does. It's got all the elements.
We'll forget the postcard views for a moment. We're diving into a Sydney legal world that was absolutely buzzing back then, especially in personal injury cases. More cars on the road meant, well, sadly, more accidents.
And more litigation. Big money, big personality.
Exactly. The legal precincts were pulsing with energy. You had these big figures vying for these high-stakes cases. But as we're going to unpack, underneath that sort of professional surface, there were practices happening that, well, they didn't just stretch ethical bounds, they smashed right through them. So our mission in this deep dive, really looking at the sources you've shared, is to unpack this really complex and, frankly, cautionary tale of New South Wales Bar Association v. Evatt, which was decided in 1968. It's the story of Clive Evatt Jr. Now, he was a young barrister born into a name that's just synonymous with Australian law. His path looked set, a stellar career ahead, but it was nearly completely destroyed by a pretty catastrophic ethical mistake.
Yeah, in this case, it's much more than just some historical anecdote, isn't it? It's a fundamental lesson, a really crucial cautionary tale that's kind of etched into legal professional conduct itself. Especially important, I think, for anyone listening who's thinking about the bar or maybe already working in law.
Absolutely.
It just starkly shows that timeless, intense conflict, between personal ambition, the drive for financial success, and that absolutely fundamental, non-negotiable ethical duty a lawyer owes to their client.
Couldn't agree more. And the sources, they give us this detailed roadmap. They show how something that maybe started as a lucrative connection just spiraled into this full-blown systematic scheme. It involved, well, alleged greed, definitely confirmed collusion, and then that inevitable, really dramatic reckoning that the legal profession has to impose on itself when its core values get compromised. So let's really get into this story.
Okay.
So to really get the context of this drama, you need to picture Sydney's legal scene back in the early 1960s. The profession had this very clear, very formal split.
Yeah, the divided profession.
Exactly. You had solicitors on one side. They were the client's first stop, right?
Yeah.
Handling the day-to-day stuff, managing the case, gathering evidence, preparing the briefs for counsel.
And then you had the barristers, the specialists, the advocates. They'd get briefed by the solicitors to give expert advice and, crucially, to stand up and argue the case in court.
And that split, it was meant to ensure a degree of detachment, wasn't it? Independence for the barrister, like a check and balance on the solicitor.
Theoretically, yes, that was the idea. Keep the advocacy objective. And it was within this system that our main players were operating.
Right.
The sources introduce us to the central figures, the real cast of this drama. And at the heart of the questionable practices were two solicitors, H.A.P. Veron and B.R.
Okay.
Now, their firm, it wasn't your standard high-end corporate practice. They really focused on and actually became dominant in representing what the sources call impecunious plaintiffs.
Impecunious plaintiffs, so people without much money.
Exactly. Often working-class people, injured in accidents, desperate for compensation. I mean, a payout could literally change their lives.
Yeah.
But they typically had very little cash up front to pay legal fees.
So, okay, they were meeting a real need then, representing clients who might otherwise have struggled to get justice, but the way they charged fees, that became the problem.
Precisely. That's where it all went wrong. Veron and Miles developed what the courts later called a systematic scheme. This wasn't just, an accidental overcharge here or there. It was a deliberate, organized way to inflate legal costs dramatically.
How did they do it?
Their method involved getting clients to agree, usually up front, to allow the solicitors to deduct really substantial sums for their fees directly from any settlement or verdict the client got. And these fees, well, the courts used some pretty strong language. Exorbitant, extortionate, and grossly excessive.
Wow.
Effectively, the system worked a lot like a contingency fee, where the lawyer takes a percentage of the win. That kind of arrangement was really frowned upon back then, seen as unprofessional.
Why was that frowned upon so much?
Because it creates a direct financial interest for the lawyer in the outcome, beyond just being paid for their work.
Yeah.
The fear was it could tempt lawyers to settle too early, or push for outcomes that maximize their cut, maybe not always what was best purely for the client.
Right, makes sense. And the scale of Veron and Miles' operation, you said it was huge.
Astounding for the time. The sources report Veron's practice alone was averaging £5,000 per verdict. Now, £5,000 in the early 60s. That's maybe $10,000 then. But think about what that could buy. It was an enormous sum. A house might only cost a few £1,000s.
So massive amounts of money flowing through this practice.
And volume.
Yeah.
Veron's firm wasn't just getting a few cases. They were reportedly handling up to 1/3 of all accident cases in the whole of New South Wales.
1/3. That's practically a monopoly.
It was incredibly dominant, and that sheer volume, combined with those huge fee deductions, inevitably started, raising eyebrows. People in the legal world started talking.
I bet. There must have been whispers, rumors.
Oh, definitely. The sources mentioned significant discontent and rumors circulating. People knew something wasn't quite right with how Veron and Miles were handling these cases, especially the costs.
Okay, so that sets the scene with the solicitors. Now let's bring in the barrister who got tangled up in all this, the focus of our deep dive, Clive Evatt Jr.
Young Clive.
Young Clive. Admitted to the bar in 1956. A young Sydney barrister, but not just any young barrister. He had, as the sources say, an impeccable legal pedigree.
Absolutely stellar connections.
His father was Clive Evatt QC, a very respected senior barrister, former government minister. His uncle, none other than Dr. H.V. Evatt. Huge figure in Australian history, High Court Justice, UN General Assembly President, Labour Party leader for ages.
And his sister, Elizabeth Evatt, also became a major legal figure, first Chief Justice of the family court.
So with that family background, you'd think his path was absolutely paved with gold, right? A stellar legal career, just waiting for him.
That was the expectation. He was often called Young Clive to distinguish him from his dad. And by all accounts, he was a talented advocate, sharp mind. But he wasn't just law. The sources paint him as this fascinating character, loved opera, art, apparently even a pretty successful horse bettor.
A bit of a Renaissance man, perhaps?
You could say that. Had a certain flair, even early on.
So how does someone with that background, that seeming promise, get mixed up with solicitors running a scheme like the one Veron and Miles had going?
Well, the sources say he was drawn into the orbit of Veron and Miles. Think about it. These solicitors had this massive volume of work, maybe a third of the state's personal injury cases. They needed barristers to handle the court work.
And Evatt became their go-to guy.
He became the barrister they routinely hired for a lot of these cases. For a young barrister trying to build a practice, getting briefs from a firm with that kind of volume,
Yeah.
well, it would have been incredibly appealing. A fast-track to court experience and income.
A poisoned chalice, perhaps?
Ultimately, yes. That connection, initially just a professional opportunity, became the very thing that nearly ended his career.
Before we really unpack the scheme and exactly what Evatt did, maybe we should quickly mention the other key people who pop up in the court proceedings, the legal teams involved.
Good idea, because there were some heavy hitters. When Evatt faced disciplinary action, he had a seriously illustrious defense team. Leading the charge was Tom Hughes, QC.
Tom Hughes, a big name even then.
A real rising star, known for being incredibly sharp, a formidable presence in court. He was assisted by T.O.L. Reynolds.
And who is arguing the case against Evatt for the Bar Association?
That was A.B. Kerrigan, QC, and I.F. Shepard. The Bar Association, as the professional body, brought the action.
And the solicitors.
Evatt's solicitors were Colreevy, O'Leary, and McGinty. The Bar Association was instructed by Murphy and Maloney. These teams basically stayed consistent through the main proceedings.
And the judges. We need to know who is hearing these cases.
Right. In the Supreme Court of New South Wales, the Court of Appeal that heard the main disciplinary case against Evatt, the bench was headed by Chief Justice Sir Leslie Heron, a very dignified figure. Alongside him were Justices Cyril Sugarman and Patrick McClelland.
And crucially, these were the same judges who'd already dealt with Veron and Miles.
Exactly. They knew the background intimately. They'd already found the solicitors guilty of misconduct. That's a pretty significant context for Evatt's hearing.
Was there another court involved briefly? Something about an injunction?
Yes. Evatt tried to stop the proceedings early on. That attempt went before Mr. Justice Lawrence Street in the Equity Court. We'll get to that.
Okay. And then the final stage, the High Court appeal.
The ultimate appeal. Heard in Canberra by a bench of 5 High Court justices, Chief Justice Garfield Barwick and Justices Kiddo, Taylor, Menzies, and Owen.
And you mentioned the Barwick connection, political rival of Evatt's uncle.
Yeah, it's a fascinating historical footnote. Barwick and H.V. Evatt were major political figures on opposing sides years before. But as the sources stress, and the judgment makes clear, that history played zero part in the High Court's decision. It was all about legal principle.
Okay, good to clarify. So that's our cast. Now let's really dig into the nuts and bolts of this scheme. How did it work, this dynamic between Veron, Miles, and Evatt? How did they get those exorbitant fees?
It really preyed on the vulnerability of the clients. Remember, these were impecunious plaintiffs, often not sophisticated about legal matters, probably incredibly stressed by their injuries, maybe losing income. They were desperate for compensation.
An unequal power dynamic from the start.
Absolutely. They trusted their lawyers completely.
Yeah.
And the scheme targeted those solicitor-client costs.
Right. You mentioned two types of costs, party and party.
Yeah, party and party costs are what the losing side might pay the winner, based on a court scale. It almost never covers the actual total cost the client has to pay their own lawyer.
And that total cost is the solicitor-client cost. That's where the big money was.
Exactly. That's the bill the client gets from their own solicitor for all the work done. And this is where Veron and Miles went, as the courts found, grossly overcharged beyond the usual party and party costs. We're talking sums that had no real connection to the work actually performed or the benefit the client received. Just huge markups.
And Evatt's role, it wasn't just getting the briefs and appearing in court, it went deeper.
Fundamentally deeper, yes. The courts found he was much more than just a passive barrister taking instructions. He was briefed in 18 specific cases. The courts looked at closely 9 by Veron, 9 by Miles over about 2.5 years, from early 63 to mid-65. And the finding was he became an active participant in this systematic course of action. His actions weren't just advocacy. He was advising clients on whether to accept settlement offers. And crucially, the finding was these settlements were often structured specifically to facilitate the generous fee deductions that the solicitors planned to take.
So he was involved in setting up the deals that allowed the overcharging?
That was the finding. And on top of that, he was found to be charging his own excessively high fees as counsel in these cases. Fees that were well above the norm for a barrister of his standing at the time.
And how did they actually get the money out of the settlement before it reached the client? You mentioned authorities.
Yes, these written authorities were absolutely key to the scheme and to Evatt's involvement. He would often prepare these documents or at least get the client to sign them. They basically authorized the solicitor to deduct specific, often very large sums for legal costs directly from the verdict or settlement money before the client got their share.
So the client signed away part of their compensation?
Pretty much. And the most damning finding, repeated again and again by the courts, was that Evatt knew his inflated fees would be paid out of the spoils of the solicitors overcharging. He wasn't ignorant of where the money was coming from. He was found to have knowingly shared in the proceeds of this improper scheme.
When this all came out, what was his defense? How did he explain his actions?
His consistent line throughout the whole disciplinary process was basically that the financial deal between a solicitor and their client about the solicitor-client costs, well, that was their business, not his concern as the barrister.
He tried to maintain that separation of roles.
Yes. He argued his job was to advise on the settlement amount against the defendant, the legal merits, not to police the solicitor's private fee arrangement with the client. He claimed he was in no way concerned with those internal costs.
But the courts didn't buy that.
Not at all. They rejected it emphatically. Why? Because the evidence showed he wasn't just a passive bystander. He did actively concern himself with those solicitor-client costs.
So,
by advising clients on settlements where he knew these huge deductions were baked in. And even more directly, by preparing and witnessing the signing of those very authority documents. He was facilitating the mechanism by which the overcharging happened. He couldn't then claim it was none of his business.
let's make this concrete. Can you walk us through one of the specific examples the sources mention, like the Jarosco v. Connell case?
Right. This is a really clear example. It was a case handled by the solicitor B.R. Miles, and Evatt was briefed alone for the plaintiff, Mrs. Jarosco. A settlement offer came in from the defendant, £1,500 plus the standard party and party costs.
Okay, £1,500. What did the solicitor, Miles, want to charge?
Miles told Evatt he wanted to take £750 just for his solicitor-client costs. That's on top of whatever party and party costs he'd get from the defendant. Yeah. £750 out of a £1,500 settlement is, well, half.
A huge chunk. What did the client want?
Mrs. Jarosco was clear. She wanted £1,000 clear to herself after everything was paid.
So there's the conflict right there. Miles wants £750 plus costs. Client wants £1,000 clear. The numbers don't add up.
Exactly. An impasse. The settlement was at risk. If they couldn't agree, the case would have to go to trial, and Evatt might lose the brief entirely.
What did Evatt do? Did he step back?
No. This is where the courts found he actively facilitated. He didn't just say, sort it out with your solicitor. He intervened. He requested the solicitor to review the deductions from the verdict. He asked Miles to reconsider his fee.
Did Miles lower his demand?
He did. Miles, probably wanting the deal to go through, reduced his demand for solicitor-client costs from £750 down to £500.
Okay, so Evatt helped negotiate the solicitor's fee down, but still £500 was being deducted. What happened next?
Then, Evatt obtained the written authority document from Mrs. Jarotzko, and the sources give us the key wording. It was addressed to Miles, prepared by Evatt, signed by the client. It said something like, "I authorize you to settle for £1,500. I understand not all costs will be recovered from the defendant, but I agree to pay these sums, on the condition that same do not exceed £500. This settlement is made on the clear understanding that I shall receive £1,000 clear to myself after all deductions."
Hold on, it explicitly says, on the clear understanding that I shall receive £1,000 clear.
That's what the document stated, according to the court records.
But did she get £1,000 clear?
No, because Evatt knew, the court found, that Miles intended to take not just the £500 solicitor-client costs mentioned in the authority, but also the party-and-party costs recovered from the defendant, which were about £294.
So Miles took £500 plus £294 costs, nearly £800 in total costs.
That's right, £794 in total. From the £1,500 settlement, that left the client with only £706, significantly less than the £1,000 the authority document, prepared by Evatt, said was the clear understanding.
Wow, so Evatt got her to sign a document based on an understanding he knew wouldn't be met.
That was the court's finding. He actively facilitated the solicitor taking a sum by preparing an authority that referenced terms of £1,000 clear that weren't actually going to be fulfilled because of the deductions he knew were planned. It's a stark example of his involvement in the mechanism.
Okay, that's pretty damning. What about the other example, Hume v. Middleton? This involved the other solicitor, Veron.
Yes, H.A.P. Veron, the one seen as the main architect of this scheme. This case was a bit different, a claim under the Compensation to Relatives Act. A widow, Mrs. Hume, and her children suing after a fatal accident. Evatt was briefed by Veron. Interestingly, he was briefed alongside a Mr. C.R. Evatt Q.C., likely his father, or another senior Evatt relative. Suggests it was seen as a significant case.
And Evatt knew Veron's reputation for high cods already.
He admitted he did. He knew Veron had a history of deducting very substantial sums from verdicts in these types of cases, which of course makes his later actions even more problematic.
What happened in the Hume case?
It settled during the hearing for a large sum, £14,500. Evatt advised Mrs. Hume to accept this settlement.
And again, was there an authority document involved?
Absolutely. Just like in Jarotzko, Evatt prepared the authority document for Mrs. Hume to sign, addressed to Veron. The wording, again from the sources, was similar in structure. I authorize you to settle for £14,500. I realize not all legal costs will be allowed against the defendant, but nonetheless I agree to pay these sums, on the condition that same do not exceed £1,100. This settlement is made on the clear understanding that I and my children will receive £80,250 clear after all deductions.
£1,100 authorized for solicitor-client costs this time, plus party costs on top.
Yes, Evatt stated he knew the settlement was based on Veron deducting that £1,100 from the £14,500 for his solicitor-client costs. Now, from the £14,500, there was a significant amount, £1,428, repaid for workers' compensation. Then the court split the rest. About £2,250 went into court for the children. Mrs. Hume's share was around £7,220.
And Veron took his costs from her share.
He took the £1,100 authorized solicitor-client costs, plus £375 recovered as party-and-party costs. So over $1,475 in total costs came out. This left Mrs. Hume with roughly £6,000 from her share. Again, potentially different from what the clear understanding figure in the authority might have implied, although the calculation is a bit more complex with the compo repayment and apportionment.
But the pattern is clear. Evatt preparing documents that authorize large solicitor deductions, knowing they're happening.
Exactly. Across these examples and the 18 cases examined, the High Court saw a consistent pattern. Evatt wasn't just a detached advocate. He was found to be knowingly a party to, actively assisted in, and facilitated the solicitor's practice of charging these extortionate and grossly excessive sums. He got the authorizations, and he charged his own high fees knowing they were funded, in part, by money improperly taken from the client's compensation. He knowingly shared in the proceeds of what the courts called an exercise in calculated greed.
It paints a really bleak picture of a barrister crossing a fundamental line, enabling, even profiting from, client exploitation. So how did this whole thing unravel? How did the system catch up? Let's talk about the timeline, the procedural reckoning.
Well, interestingly, the accountability process didn't start with Evatt. It started with the solicitors.
They faced the music first.
Yes. In 1966, the year before the Bar Association formally moved against Evatt, the Supreme Court of NSW, that same Court of Appeal bench, Heron C.J., Sugarman J., McClellan J. heard cases against Veron and Miles.
Brought by the Law Society.
Correct. The Law Society of NSW, the solicitor's professional body, brought complaints detailing this systematic overcharging across more than 65 cases. Mostly these personal injury matters, where Veron's firm had that practical monopoly.
And the court's findings against Veron and Miles, were they tough?
Extremely tough. The court found both of them guilty of professional misconduct for systematic overcharging. The language was blunt. Outrageous overcharging, an exercise in calculated greed. They noted the firm practically monopolized the area, leaving clients little choice.
What penalties did they get?
H.A.P. Veron, seen as the mastermind, was struck off the roll of solicitors. Career over. B.R. Miles got a 2-year suspension from practice. The court said a really stern message. Exploiting vulnerable clients through excessive fees was intolerable, a fundamental breach of trust. Now, it was during these very public, detailed hearings against the solicitors that Clive Evatt Jr.'s name kept coming up. Surfaced repeatedly, as the sources put it.
He was the common link, the barrister they both used.
He was the common link. Briefed by both Veron and Miles in many of the cases under scrutiny. The evidence revealed not just his role in getting those fee authorities signed, but also that he'd drawn unusually high counsel fees himself from these cases. Fees well above the standard rate for a barrister of his seniority at the time.
So even though he wasn't formally part of those solicitor hearings, his conduct became part of the official record.
Exactly. And you can bet the New South Wales Bar Association was paying close attention. They had a duty to uphold the bar's integrity. Armed with all the evidence from the Veron Miles cases, they quietly began compiling the evidence implicating one of their own.
Which leads us to phase 2. The Bar Association takes formal action against Evatt himself.
Right. The first formal step was in September 1966. The Bar Council sent a letter to Clive Evatt Jr. It referenced the evidence about him from the Veron Miles cases, noting certain actions on Evatt's part which required explanation, especially regarding the solicitor's extortionate costs.
Was that an opportunity for him to explain himself internally?
The Bar Association certainly argued it was. Evatt, however, later maintained he was never invited to a proper, formal internal inquiry where he could really present his side before they went to court. That became a point of contention later.
But whether there was a proper internal chance or not, the Bar decided to proceed formally.
They did. Things moved quickly into the public legal arena. On February 15, 1967, the NSW Bar Association filed a formal notice of motion in the Supreme Court. They asked the Court of Appeal directly to declare that Clive Evatt Jr. was guilty of professional misconduct for his actions between early 1963 and mid-1965. The core allegation: he, quote, assisted 2 solicitors to charge extortionate and grossly excessive fees.
So the Bar was asking the highest state court to rule on his conduct. Who represented the Bar Association in this serious step?
As we mentioned, A.B. Kerrigan QC and I. F. Shepard were counsel for the Bar Association, instructed by Murphy and Maloney solicitors.
And Evatt, facing this formal charge, obviously needed a strong defense.
Absolutely. His career was squarely on the line. He put together that illustrious defense team we talked about, led by Tom Hughes QC, with T.O.L. Reynolds and solicitors Colreevy, O'Leary, and McGinty.
Now, before the main hearing got underway, Evatt's team tried something unusual, didn't they? That injunction attempt.
That's right. A bit of procedural maneuvering. Before the Court of Appeal could hear the Bar's motion, on March 29, 1967, Tom Hughes went to the Equity Court before Justice Lawrence Street. He asked for an injunction, a court order, to stop the Bar Association from going ahead with the disciplinary hearing.
On what grounds could they try and stop it?
The argument was all about procedural fairness, or natural justice. Hughes argued Evatt had been denied fairness because the Bar Association hadn't held a proper inquiry internally first. The idea was a professional body should investigate fully, give the member a proper chance to respond internally before taking the huge step of launching public court proceedings. Hughes argued skipping that step denied Evatt natural justice.
That must have caused quite a stir. A barrister suing his own bar.
Huge stir. An unusual spectacle, as the sources say. Son of a famous legal family fighting his own professional body in court. The media picked it up. Evatt restraint move succeeds, was one headline when a temporary halt was granted.
But it was only temporary.
Very temporary. A short-lived victory. Within about a week, the injunction fight was resolved. The Equity Court presumably decided the Bar was entitled to bring the matter directly to the Supreme Court for determination. So the injunction failed, and the Bar Association's main notice of motion against Evatt was set down for hearing in the Court of Appeal, starting just days later, April 3rd, 1967. The showdown was on.
Okay, phase 3. The Supreme Court showdown. This is where the core findings against Evatt are made. Who was on the bench again?
It was the Court of Appeal. Chief Justice Sir Leslie Herron, Justice Cyril Sugarman, and Justice Patrick McClelland. The same judges who'd already handled the Veron and Miles cases, so they knew the territory very well.
And Evatt was there.
Yes, present throughout. Sitting in his barrister's robes, but in that unfamiliar position of respondent, facing judgment from his peers and superiors. The atmosphere must have been incredibly tense.
Same legal teams arguing the case.
Yes. Kerrigan QC and Shepard for the Bar Association pushing the misconduct case. Hughes QC and Reynolds for Evatt defending him. Same solicitors instructing.
What was the evidence the Court of Appeal looked at?
The Bar Association brought the evidence from the Veron Miles inquiry. The documents, the client accounts, the fee structures. It was already a damning record. Evatt provided his own evidence in response. But the sources really stressed that the case against him was ultimately seen as overwhelming, relying heavily on his own admissions about preparing authorities and advising on settlements, not just on disputed testimony.
And what was the main thrust of Evatt's defense in court, argued by Hughes?
They stuck to his line. He always acted in the client's best interest. He denied knowingly doing anything wrong. He believed the settlements were proper, and the solicitor-client fee issue wasn't his domain. They probably also emphasized his relative youth and inexperience at the time. He was only in his early 30s when this was happening, trying to paint it perhaps as naivety or being unduly influenced rather than active, knowing participation in wrongdoing. But the court didn't accept that mitigation. On April 28, 1967, they delivered their judgment, found Clive Evatt Jr. guilty of professional misconduct. They accepted the Bar Association's case. He had actively assisted and facilitated Veron and Miles' scheme of charging extortionate and grossly excessive fees.
How did the judges describe his actions? You mentioned scathing.
Very much so. Chief Justice Herron found Evatt charged his own fees that were beyond recognized standards, excessive and unjustified. And the killer finding. Evatt knew these high fees would be paid in part from the amounts extorted by the solicitors. That finding of knowledge was critical. It meant he knowingly shared in the proceeds. And his claim that he didn't really understand the impropriety, how did they handle that? They were completely unmoved as to culpability. In fact, they turned it against him. His very failure to grasp the wrongfulness was seen as a grave indictment. Justice Sugarman made that powerful point for a lawyer whose profession relies on trust and ethical judgment. Failing to see such obvious misconduct of itself indicates unfitness. It demonstrated a dangerous blind spot.
Despite findings this serious, the penalty wasn't striking off, was it?
No, it wasn't. The Supreme Court ordered Evatt be suspended from practice as a barrister for 2 years. They specifically chose not to remove his name from the role permanently.
Why suspension, given how damning the findings sound?
The court called it an exercise of mercy or measured discipline. Chief Justice Herron said they considered extenuating circumstances, specifically his age at the time, and what they saw as the possibility he had not understood the error of his ways fully back then.
So they held out some hope for him.
It seems so. The implication was maybe this was an isolated lapse by a young barrister led astray, rather than proof of fundamentally flawed character. They seemed to think a 2-year suspension would be enough punishment and time for reflection, allowing for possible reform. Certain factors were explicitly listed as extenuating.
How did the legal profession react to that suspension?
It was definitely mixed. Some might have felt relieved that a promising career wasn't totally extinguished. But many, especially the Bar Association leadership who brought the case, felt it was too lenient, a betrayal even of the duty to protect the public. They believed the findings absolutely mandated disbarment.
So the Bar Association wasn't happy with the outcome.
Not at all. They felt the suspension didn't match the gravity of the misconduct. So they made the big decision to appeal the penalty to the High Court of Australia. They wanted the High Court to overturn the suspension and order that Evatt be struck off instead. And Evatt? He appealed too. Yes, he lodged a cross appeal. He was still hoping to overturn the finding of misconduct altogether, or at least get the High Court to reduce the 2-year suspension. So both sides took it to the highest court.
Which brings us to Phase 4, the appeal to the High Court of Australia, the final legal battle.
Exactly. Early 1968, the appeals land in the High Court in Canberra. A really momentous hearing, given everything at stake. The bench of 5, Chief Justice Barwick, Justices Kiddo, Taylor, Menzies, and Owen.
And you mentioned the Barwick-Evatt family history element, but stressed it didn't influence things.
Right. Purely a historical curiosity. The High Court's judgment focused solely on the legal principles of professional conduct and the facts found by the Supreme Court.
Same legal teams arguing again.
Yes. Kerrigan QC and Shepard for the Bar Association, arguing for striking off. Hughes QC and Reynolds for Evatt, arguing against misconduct, or at least for upholding the suspension. Same solicitors behind them.
What was the core of the Bar Association's argument to the High Court? Why did they insist on striking off?
Their argument was straightforward and principled. They said the Supreme Court's penalty just didn't fit the crime, didn't fit the court's own findings, finding that he knowingly shared in the proceeds and actively assisted the scheme. That demonstrated unfitness, they argued. It compelled the conclusion he shouldn't be a barrister.
They emphasized the systemic nature.
Yes, this wasn't one mistake, but a systematic course of action over years. And they hammered home that core principle. Discipline is protective, not punitive. The aim isn't to punish Evatt, but to protect the public and the profession's integrity from someone shown to be untrustworthy. A 2-year suspension, they argued, didn't adequately protect the public.
How did Tom Hughes counter that for Evatt? What was his argument to keep the suspension?
Hughes essentially asked the High Court to respect the Supreme Court's discretion. He'd argue that while the misconduct was serious, it didn't reach the level requiring the professional death sentence of disbarment. He likely re-emphasized the argument about Evatt's youth, maybe a lack of full appreciation of the gravity at the time, framing it as perhaps terrible judgment influenced by others, not inherent dishonesty. The plea would be, the 2-year suspension was enough, let it stand. The High Court delivered its judgment on May 3, 1968. It was unanimous, clear, and decisive.
What did they decide?
They were not persuaded by the plea for leniency. They allowed the Bar Association's appeal, meaning they agreed the suspension was too lenient, and they dismissed Evatt's cross-appeal, upholding the misconduct finding and rejecting any reduction in penalty.
So what were the High Court's key findings that led them there?
They stated flatly that the proven facts demonstrated unfitness to be a member of the bar, not some isolated or passing departure from standards. The Supreme Court's own findings, they said, compelled the conclusion that he should be disbarred. For the High Court, suspension wasn't an option on these facts.
And they really laid down the law on the principles of professional conduct, didn't they?
Absolutely. Their reasoning became fundamental in Australian legal ethics. First, that protective nature of discipline. It's entirely protective, no element of punishment involved. It's about safeguarding the public and the profession's standing. They explicitly said the Supreme Court erred by letting mercy temper the decision when protection should have been paramount. Second, and this was powerful, they tackled Evatt's claim of not understanding the wrongfulness. The High Court said the respondent's failure to understand the error of his ways of itself demonstrates his unfitness. If you can't even see that what you did was wrong on this scale, you lack the basic ethical judgment required of a lawyer. That blind spot, they said, made him all the more dangerous to clients. It wasn't mitigating, it was aggravating, proof of unfitness.
So with those findings, what was the High Court's final order?
They set aside the Supreme Court's 2-year suspension order, and in its place, the High Court ordered that Clive Evatt Jr.'s name be removed from the roll of barristers of the Supreme Court of New South Wales. Struck off.
The ultimate professional disgrace.
That's exactly how the sources describe it. Career over, at least at that point.
What was the immediate reaction to that High Court ruling?
Huge shockwaves. It made national headlines. Nephew of H.V. Evatt, son of a QC, publicly drummed out of the profession by the highest court. It became the definitive cautionary tale. The dramatic rise, the connections, then the absolute precipitous fall due to ethical failure.
A devastating end to that chapter. But, as you hinted, remarkably, it wasn't the absolute end of Clive Evatt Jr.'s story in relation to the law. There's an epilogue.
There is. A quite remarkable second act, actually. While the 1968 High Court decision effectively ended his legal career then and there, he was forced into exile from the bar, but not from public life entirely. This exile lasted 13 years.
13 years off the roll. What did he do during that time?
He turned his energies elsewhere. Sources say he became reputedly very successful betting on horses. And he also became quite a prominent figure in the Sydney art world, opening a well-known art gallery in the 1970s. Lived an eclectic life, maintaining that sort of Renaissance man persona. And the solicitors. What happened to Veron and Miles in the long run? H.A.P. Veron, having been struck off, never returned to legal practice. B.R. Miles served his 2-year suspension and presumably resumed practice afterwards, but always, you'd imagine, under the cloud of the prior misconduct finding.
So after 13 years away, Evatt decided to try and get back into the profession.
Yes. In the late 1970s, he started the process, leading to a formal readmission application heard by the NSW Court of Appeal in 1981.
How could he possibly get readmitted after being struck off by the High Court for such serious misconduct? That seems extraordinary.
It is rare, but possible. The 1981 Court of Appeal unanimously concluded that Evatt had, over those 13 years, genuinely rehabilitated himself and was, once again, a fit and proper person to practice law. What convinced them? They needed strong evidence. The court was heavily influenced by testimony from many people who had dealt with Evatt in his business life, the art gallery, perhaps other dealings, and personally during his hiatus. These people attested to his honesty, integrity, and good character in those non-legal interactions. Multiple reputable members of the community vouched for him, essentially saying he was a changed man, that the conduct from the 60s no longer reflected his character.
So the court accepted he'd truly reformed.
They did. They believed the evidence showed the blind spot and the ethical failings from the past had been addressed, and he was now fit to be trusted again. So in 1981, Clive Evatt Jr. was formally readmitted to the bar roll.
Closing the circle, as the sources say, a remarkable second act. Did he go on to practice successfully after that?
He certainly did. He rebuilt his career and became, over the following decades, quite an institution at the Sydney bar. He didn't go back to personal injury law, interestingly. He became very well known and respected, particularly for his work in defamation cases.
How was he perceived by colleagues in that later career?
Descriptions suggest a mix of flamboyance and humility. He was reportedly often quite self-deprecating about his early mistakes, if the topic came up, but was still known as a fierce advocate for his clients. He remained active and respected at the bar until he passed away in 2018. He earned back respect as a talented lawyer who had undeniably learned some very hard lessons. He even apparently mentored junior barristers, sharing his perspective on ethics based on his own painful experience. And the whole Veron Miles Evatt saga itself, it became embedded in legal history. Oh, absolutely. Part of NSW legal folklore. It's still often discussed in law school ethics classes and professional seminars all over Australia. It's just such a vivid example of how not to conduct oneself, especially regarding fees, independence, and the barrister-solicitor relationship.
It's an incredible personal story, that fall and eventual return. But let's broaden out now. What are the big, lasting ethical and professional takeaways from this case? Why is Evatt still considered such a landmark for lawyers, especially barristers, today?
It remains a landmark because it hits so hard on fundamental principles. NSW Bar Association v. Evatt, 1968, is constantly cited for its clear statements on professional misconduct and discipline. The absolute core message for anyone in law, especially at the bar, is stark. Your professional integrity is your most precious asset. Full stop.
And the case is a warning about compromising that asset.
A massive warning, especially when faced with financial temptations or pressure from instructing solicitors. Evatt shows the catastrophic cost of getting that balance wrong.
And the fact it wasn't just one mistake, but a systematic course of action, that's key.
Crucial. The High Court stressed that. It wasn't a slip-up. It was a pattern over years. It shows how easily misconduct can become entrenched and just poison an entire career. So let's break down the main implications, the big lessons from the sources, and the case itself.
Okay, first, that fundamental duty to the client.
Bedrock principle. Lawyers' duty to the client is paramount. You never put your own profit, or the solicitor's profit, ahead of the client's well-being. Evatt's core breach was facilitating a system where the lawyer's financial gain was prioritized above the interests of vulnerable clients who ended up with less compensation. That's a total betrayal of the fiduciary nature of the lawyer-client relationship. The duty of loyalty and trust. And modern rules reflect this strongly, right?
Absolutely. Professional conduct rules today hammer this home. Costs must be fair and reasonable. Gross overcharging, like Evatt facilitated, is defined as serious misconduct and can absolutely lead to discipline, including being struck off. The Evatt case stands as proof. Second key lesson, the barrister's independence and integrity.
This is huge for the bar. A barrister isn't just a hired gun doing whatever the solicitor says. You have to maintain ethical independence. You exercise your own judgment, including ethical judgment. Evatt failed this test completely. Instead of questioning or blowing the whistle on Veron and Miles's obvious exercise and calculated greed, he became an enabler. So, the solicitor told me to is never an excuse.
Never. As the High Court showed, it's no excuse for misconduct if the barrister actively participates or facilitates. Modern bar rules are even clearer. Barristers have a duty to refuse unethical instructions and even report illegal or unethical conduct they become aware of, no matter the pressure. The High Court's emphasis on discipline being protective, not punitive. That's another really significant principle from Evatt.
Foundational. Constantly cited. Building on earlier cases like Klein, the High Court in Evatt made it crystal clear. Disciplinary proceedings are entirely protective. The goal isn't to punish the lawyer, however bad the conduct. It's solely to protect the public and the profession's reputation by removing people who've shown they aren't fit to be trusted. What does that mean practically, especially for younger lawyers?
It means if your conduct shows a fundamental lack of integrity or ethical insight, don't expect mercy based on personal factors. Regulators and courts will likely act swiftly to remove them from practice, and they'll do it irrespective of personal mitigation, your age, your potential family hardship. Good character and ethics aren't optional extras, they're essential prerequisites. And this contrasts with cases where the misconduct is outside legal practice.
Right. Like the Zeems case mentioned in the source's manslaughter conviction from drunk driving. Terrible, but the court found it didn't directly prove unfitness as a lawyer in the same way. Evatt's misconduct was, in his practice, directly harming clients through financial impropriety. That made it a direct reflection on his fitness as a lawyer, making disbarment for the High Court the only acceptable outcome for public protection.
Another clear takeaway. Nobody is above the law, no matter their name or connections.
Definitely. Evatt's prominent family didn't shield him. His family name and connections did not save him. If anything, the sources suggest the bar felt even more need to act decisively to show favoritism played no part. And that's crucial for public trust, isn't it?
Absolutely. It bolsters public confidence when people see the profession policing itself without fear or favor, holding everyone to the same high standard. Think of former Judge Marcus Einfeld, also struck off later for lying, same principle. The profession's legitimacy depends on it. But the readmission does add that nuance, that possibility of redemption.
It does. It shows striking off isn't always a life sentence professionally. Lawyers can earn a second chance. But, and it's a big but, only after demonstrating genuine reform over a long period. Evatt's return after 13 years shows it's possible if you can conclusively show restoration of character. What's the standard for that?
Very high. The burden is completely on the former lawyer. You need credible evidence of probity during your time away, usually backed up by multiple reputable members of the community vouching for your transformation. Reinstatement applications happen, but success is high, and success is rare as it should be to maintain that protective principle.
Are the kinds of ethical issues seen in Evatt still relevant today? Do we see similar cases?
Oh, yes. The core issues, excessive fees, exploiting vulnerable clients, conflicts of interest, their perennial challenges, modern conduct rules cover them explicitly. The sources mentioned the Roche case from 2002 and the ACT systemic overcharging via cost agreements, described in language echoing Evatt. Extortionate, exercising calculated greed. The penalties might vary, but courts still view this kind of conduct incredibly seriously. Did the Evatt case change the culture at the NSW bar? Or the legal profession more broadly?
It was undoubtedly a major wake-up call back in the 60s. It highlighted the bar's need to be vigilant about its own members and about the conduct of solicitors they work with. It likely pushed for better cooperation between the Bar Association and the Law Society on misconduct issues. Any practical changes?
Well, it certainly reinforced the need for transparency around fees. Detailed cost agreements and disclosures are legally mandated now, partly to prevent the kind of hidden, excessive charging seen in the Evatt scheme. And as we said, the case is used constantly in ethics training. Young barristers get the message loud and clear. Getting into bed with a dodgy solicitor can end your career. It's an extreme but instructive cautionary tale. It really brings home that the law isn't just another business.
Exactly. It's a profession governed by duties of honesty, integrity, service. When those are breached so fundamentally, the system have to act. Reputations crumble, careers end, all in service of the higher principle that the public must be able to trust their lawyers.
So, if we boil it all down, what's the enduring moral of the Evatt story?
It's uncompromising, really. For any lawyer, honor and honesty must triumph over ambition and greed every time.
Clive Evatt Jr. did manage that remarkable second act, earning back his place. But the price was enormous, 13 years in the wilderness, the public humiliation. It's a path nobody would choose.
And the story isn't just history, because those pressures, the drive to win, to earn, to please instructing solicitors, they still exist today. Maybe in different forms, but they're there.
It's a powerful reminder, especially for barristers, of that need for independence, for being your own toughest moral guardian.
Absolutely. You are the final check on your own integrity.
So, as we wrap up this deep dive into a really pivotal piece of legal history, maybe a final thought for you, the listener, to consider. Thinking about your own professional life, whether it's in law or any field built on trust, where is that line between pushing hard for a client, for a deal, for success, and crossing into unethical territory? What pressures might you face, and how would you make sure you navigate them, keeping in mind the stark lessons of Clive Evatt Jr.?
The specific people in this drama, Veron, Miles, Evatt, they've left the stage. But the moral of their story, it absolutely endures. The legacy of the Evatt case is a legal profession that is hopefully more aware, more vigilant, and more firmly guided by its ethical compass because of it.